My name is Emily Jones, and today we will be talking about defamation and its relationship to public relations law. The case at hand involves Lachlan Garita, a former movie star turned politician, who will be standing to the Australian Senate as an independent senator for Western Australia. Lachlan sees his personal style as his trademark. Flynn McGill is a US political commentator who has published an article in the online US newspaper, The Democrat, that criticises Lachlan. The article written by McGill claims that Garita is so 2000s, is Hitler's biggest fan, needs serious Botox and is a total sleaze. There is no evidence to support any of these comments published. It must be noted that although The Democrat is an online US newspaper, it has up to 10,000 readers living in Australia who subscribe to the weekly publication. The area of law concerning this case is the elements of defamation and the relevant defences. The principles of law involve satisfying the elements of defamation, which include defamatory matter, reference to the plaintiff, and publication to a third party. Defamatory matter is defined in Section 4 of the Defamation Act as spoken or written word, expressed or implied, that has a potential to damage another's reputation. It may do so by exposing them to hatred, contempt or ridicule, causing one to be shunned or avoided, and whether an average person would interpret the matter as defamatory. In the case of Random House Australia versus Abbott, unfounded rumours were published surrounding Abbott's sexual encounters, suggesting that these acts swayed his political position. The appeal by Random House of Australia was dismissed on the grounds that the imputations of the matter acted in a defamatory way and exposed Abbott to ridicule. In the case of Burkhoff versus Birchill, the plaintiff, a well-known actor, director and writer, was described by the defendants as being hideously ugly. The court ruled in favour of the plaintiff, stating that the statement would cause others to shun or avoid him. In the case of Saunders versus National Wide News, the plaintiff, a 7-year-old boy, brought forward a defamation action against journalists who reported on his accident where he received severe burns following his involvement in petrol sniffing. The plaintiff claimed that the imputations of the matter would lead others to think less of him. The case was dismissed. Although the court accepted the imputations of the matter, they ruled in favour of the journalist, stating that no one of average intelligence would think any less of a 7-year-old boy involved in such a pitiful situation. Reference to the plaintiff is the second element of defamation that must be satisfied. Proof of the publication being of and concerning the plaintiff must be demonstrated. Intention is irrelevant. Where the plaintiff is identified by name, the element of and concerning the plaintiff is satisfied. The third and final element of defamation is publication to a third party. Critical to this case is the place of publication and is addressed in Section 11 of the Defamation Act 2005. It must be noted that internet publication takes place when material has been downloaded, identifying which jurisdiction's laws will apply. Where place of publication is across multiple jurisdictions, it will be determined where the harm has its closest connection, in reference to where the plaintiff lives and is employed. The Gutnick case highlights the relevance for the place of publication element in proving for defamation. Gutnick of Victoria sought to bring defamation against New Jersey-based financial magazine The Barron for defamatory matter published in their online edition. Although the defendant argued that the place of publication had occurred in New Jersey, the High Court of Australia ruled in favour of Gutnick, stating that the download or place of publication had occurred in Victoria, where the plaintiff resided and was employed. In the case of defamation actions involving politics or politicians, the defendant may claim defence for extended political qualified privilege where there is an assumption by the courts that there is a duty for disclosure and an interest on the part of the audience. The defendant must prove that their actions were done on reasonable grounds and that there was an attempt to verify information, an opportunity offered for response. In the case of Lang versus Australian Broadcasting Corporation, New Zealand Labor Party member David Lang sought to bring defamation action against the ABC for criticism of private sector funding. The ABC then sought to rely on the defence for extended political qualified privilege. The defence was overturned when Lang challenged the ABC did not offer the New Zealand Labor Party the opportunity to respond. Section 31 of the Act details honest opinion. In proving for honest opinion, the matter must be an expression of the defendant's opinion rather than one of fact. The opinion must be relative to public interest and proper material must support the opinion. In the case involving Blue Angel Restaurant versus John Fairfax and Sons, the defendant had claimed the defence of honest opinion for defamatory matter published regarding lobster he had eaten at the Blue Angel Restaurant. The court dismissed the defence on the grounds that the opinion could not be proven as fact, given that the lobster had been eaten by the journalist. To apply the law, the court will need to establish if the plaintiff, Lachlan Garita, can prove for defamation against Flynn McGill. The court will need to determine if 1. The matter published in the online US newspaper was defamatory, if 2. There was reference to the plaintiff, and finally, if 3. There was publication of the matter to a third party. With regard to McGill's comments, the courts will consider the intention of McGill's comments as irrelevant and will judge them for what was implied and for what might be considered by an average person of average intelligence. Meaning derived from the comments will be considered by the courts, and as such, imputations and innuendo will be considered for their damage brought to Garita's reputation. McGill's comments give rise to the imputations that Garita is behind the times, is of age, and is an untrustworthy character possessing extremist and dictatorship mannerisms. The imputations of McGill's words could expose Garita to hatred, contempt and ridicule, cause him to be shunned or avoided, and cause others to lower their estimation of him. Imputations aside, Garita would need to prove that the expressed and implied comments would cause that of the average person to think less of him. McGill might argue that no right-minded person would make judgments regarding Garita based on the comments published. In defence, McGill could claim for extended political qualified privilege on the grounds that the readership had an interest in the information and that the information was published to provide such material. Specifically, McGill could argue that he had a duty to his readership in disclosing the information regarding Garita's character. The court would look to identify whether McGill's conduct was reasonable in the circumstances, for which it would find that McGill had failed. McGill took no action to publish Garita's response to the publication and did not provide any supportive evidence for the comments he published. McGill may also claim defence of honest opinion. In doing so, however, he would need to support each of his comments with facts supportive of his opinions. Garita may argue that McGill's comments involved the private conduct of a public official unrelated to his fitness for office, which if held would deny McGill the defence of honest opinion. McGill could counter-argue that his comments regarding Hitler and Garita's behaviour with female colleagues was relevant to his fitness for office. The sticking point, however, is that McGill would need to provide substantive evidence which he did not publish at the time of publication. In bringing forward the action of defamation, Garita would need to prove the second element of defamation, being that the publication was made of and concerning the plaintiff. Garita would succeed and McGill would have no defence, as Garita was clearly named in the publication. The third and final element to defamation is a publication to a third party, and in particular to this case, place of publication. As Garita would be claiming for defamation within Australia, the court would look to the place of publication and where the harm of the publication had its closest connection. Garita would argue that the publication took place in Australia at the time of download to up to 10,000 readers. Given Garita's place of residence and employment being in Australia, the court may rule in favour of Garita. Advice would be that Garita has a solid case for bringing a defamation action against McGill in Western Australia under the Defamation Act of 2005. This would be supported by the fact that McGill could be proven to have satisfied all three elements of a defamation action in that he had published defamatory matter to a third party with reference to or concerning Garita, which could prove damaging to his reputation. Remedy may be awarded to Garita in damages or injunction. An injunction would prevent ongoing publication of the defamatory material and enforce McGill to remove the material from the internet. Garita may receive damages for the non-economic effect such as injury to his reputation, as well as for actual economic loss suffered if he can prove that his position as independent senator for Western Australia has been compromised. McGill may be able to avoid damages where resolve is met before litigation through an offer of amends and apology. If McGill is to offer an apology, strict wording, timing and structure to an offer of amends must be satisfied under Part 3 of the Act.